But you know what song is in my mind this morning? The Doobie Brothers, Long Train Running. I can't get it out of my mind. You know, without love, where would you be now? All right, everyone, we are actually going to start up with closing arguments in a jury trial that we're concluding today. But what I'm going to do is I am going to call the docket. When I call the docket, you need to stand and let me know that you are here. Otherwise, I'm going to assume you're not here and a warrant may be issued for your arrest. Marlon Daniels. Thank you. Dinesha Walton.
She should be on Zoom, Your Honor.
Yes, she is. Thank you. If you could confer real quickly with the state so we can take care of Miss Walton, please. Jeffrey Guerrero, custody. Pedro Rodriguez, James Davis, custody. Aaron Joseph Mendez Trevino. Thank you. Gabriela Medellin. Gabriela Renee Medellin. Mark Lunsford, custody. Lynn Marin.
Mr. Lunsford's not in custody, Your Honor. He's present with counsel.
Okay, all right. Are you on GPS maybe?
No, Your Honor. He made a bond in a different county. It said custody last time and he was not in custody. I think it's because he made bond in Brazoria County.
All right, thank you. Lynn Marin. Thank you. Dominique Grant, custody. Jesse R. Garcia. Carlos White, custody. Axel Ramirez. Thank you. Aaron Gilroy, custody. Wilfredo Mati, custody. Angel Miguel Cepedes Ronda. Thank you. Messiel Dominguez Serna. Rogelio Elizondo. Rogelio Alfonso Elizondo Jr. Fernando Alvarado. Edvigan Leal. Is he in custody? Joseph Alamon, custody. Hunter Rex Edwards, custody. Levanta Patterson. Adam Keith, custody. Michael Ray Munoz. Is he in custody or not? Hector Aguilar, custody. Lemiel Richardson.
Judge, I'm present for him.
Thank you. Jesus Aris Mendez, custody. Jordan Christopher Armstead. Hunter Edwards. Lori Valdez, custody. Justin Lee Heather III.
Good morning, Judge.
Sorry, the second. Thank you.
Thank you.
Misty Portman, custody. Luis Luna, custody. Christopher Scott Stanton. Christopher Scott Stanton. Jonathan Beebe, custody. Mahmoud El-Gadrab. Mahmoud Fuad El-Gadrab. Stephanie Luna, custody. Gerard Michael Wade.
He's present, Your Honor. May we confer?
Yes.
And may I-
Lori Valdez, custody. Jesus Aris Mendez, custody. James Cody. Jalisa Saranal, custody. Jonathan Dreamer.
Present.
Thank you. Darren Johnson, present. Edith Rosales. Edith Anthony Rosales. Ethan. All right, thank you. Sorry about that. Luis Beltran, custody. Lindsay Lorraine Hernandez.
She's on her way, but I'm following.
Thank you. Mario Tovar, custody. Mia Ray Hermio Herrera, custody. Roberto Gonzalez. Thank you. Nicholas Corpus. Thank you. Angelo Rosado.
Here.
Thank you. Daniel J. Guerrero. Thank you. Luis Brasinho. Thank you. Teresa Frias, custody. Ollie Kelly, Richard Murmea, custody. Jonathan Allen, is he in custody? All right, it showed us a fugitive. All right, thank you. Samuel Ramirez, custody. John Arredondo, custody. David Johnson, custody. Find a seat, have a seat. Gabriela Medellin. Thank you. Rogelio Elizondo,
We can't stop him.
Edna Vegan Leal, Christopher Stanton, Mahmoud Elgadrop, Lindsay Hernandez.
He's a defendant.
All right, is there anyone present and your name was not called? All right, we're gonna see if,
I've walked in a bit late, well, rolled in,
yes,
and they're in the Davis case. From yesterday,
James Davis, okay,
man,
all right. Is there anyone else present whose name was not called or you came in late? All right, everyone, we're gonna start with closing arguments today in this trial. Each side is gonna have 15 minutes, so you do the math about how long it's gonna take. What I am gonna ask, make sure that you all have your cell phones off or on silent. There is nothing worse when you're in your groove, you're doing your closing argument, you think that you're hitting all the points you need to hit, and somebody's cell phone goes off and they interrupt your flow. So make sure your cell phones are on off. And Janisha Walton, are you ready on that? And Deputy Mahia, if you get a chance, can you check to see if all the jurors are here? If they're here, we'll go with them. Yes. Yes. All right, I'm only doing one case, so everyone else, there's only one case that's happening, and that's the person that's on Zoom. Everyone else, you're gonna have to wait until they finish with closing arguments. So please don't ask me for anything else. All right, so what is happening with this case?
He's gonna give you an internal hard copy, it's gonna have everything on that, and we'll get a copy of it.
All right, so what we're gonna do on this case, we're gonna call it back to make sure that you receive the discovery. You need to make sure that they get the hard drive. Norma?
Yes, ma'am.
On this case, recall it back for June 2nd.
Yes, ma'am.
Is that good for you, Mr. Spears? Are you gonna be in trial anywhere? And, well, I will tell you what, if you all right, so if you stop here first, we'll take it up.
They can, I don't know, fine if I give it to them ahead of time.
Yeah.
Provided, I'm fine with that too, once I,
All right, Miss Janisha Walton, if you want to appear on Zoom, you're gonna need to have your video shown. And you need to unmute. All right, yeah, I don't know what you're doing with your piercing in your tongue, but we don't need to see that. We don't want to see it.
Oh, my bad. I'm at work. My bad.
All right, we don't do my bads here. We just don't do it. So if you want to continue to appear by Zoom, you need to appear appropriately dressed, and nobody wants to see you fiddling with your tongue piercing. All right, you're going to be back on June 2nd. And June 2nd, you can appear by Zoom, but if the court finds that you are not behaving appropriately on Zoom, that will be suspended. All right, thank you.
thank you.
All right, the deputy, all the jurors here? All right, everyone needs to step back. And we're gonna go on the record. Yes. Court is calling 2024 CR 2675 State versus Darren Johnson. Can I have parties announced?
Megan Galloway and Andrew Edelman for the state of Texas.
William Davidson and Robert Porter for Ms. Johnson.
And are you Ms. Johnson? All right. And have both parties had an opportunity to review the proposed charge of the court state?
Yes, Your Honor, and we have no objections.
Yes, Your Honor, no objection.
All right. Does anyone want a time announcement?
5 minutes, please.
2 minutes.
All right. And are you all splitting your time in any way?
Yes, Judge. I don't think Mr. Edelman needs a time announcement.
All right. So I'll just give 5 minutes and 2 minutes for you all.
Yes.
All right. We're ready.
All right, for the jury.
All right, everyone, please be seated. All right, ladies and gentlemen, the persons that you see in the courtroom are unrelated to this case. That's part of my morning docket. So I'm going to read to you what's called the charge of the court. It's the jury charge. You do not have to memorize it because you will be given the original when you begin your deliberations. Members of the jury, the defendant Darren Johnson is charged in count 1 of the indictment with the offense of aggravated assault with a deadly weapon alleged to have been committed on or about the 21st day of October 2023 in Bexar County, Texas. The defendant, Darren Johnson, is charged in count 2 of the indictment with the offense of injury to an elderly individual alleged to have been committed on or about the 21st day of October 2023 in Bexar County, Texas. To these charges, the defendant has pleaded not guilty. 1, our law provides that a person commits an assault if the person intentionally, knowingly, or recklessly causes bodily injury to another. A person commits the offense of aggravated assault with a deadly weapon if the person commits an assault as defined above and uses or exhibits a deadly weapon during the commission of the assault. 2, our law provides that a person commits the offense of injury to an elderly individual if she intentionally or knowingly causes bodily injury to an elderly individual. 3, deadly weapon means anything that in the manner of its use or intended use is capable of causing death or serious bodily injury. Bodily injury means physical pain, illness, or any impairment of physical condition. Serious bodily injury means bodily injury that creates a substantial risk of death or that causes death, serious permanent disfigurement, or protracted loss or impairment of the function of any bodily member or organ. Elderly individual means a person 65 years of age or older. 4, a person acts intentionally or with intent with respect to a result of her conduct when it is her conscious objective or desire to cause the result. A person acts knowingly or with knowledge with respect to a result of her conduct when she is aware that her conduct is reasonably certain to cause the result. A person acts recklessly or is reckless with respect to circumstances surrounding her conduct or the result of her conduct when she is aware of but consciously disregards the substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all the circumstances as viewed from the actor's standpoint. 4, count 1, aggravated assault with a deadly weapon. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2023 in Bexar County, Texas, the defendant, Darren Johnson, did use or exhibit a deadly weapon namely a motor vehicle that in the manner of its use or intended use was capable of causing death or serious bodily injury, and Darren Johnson did intentionally, knowingly, or recklessly cause bodily injury to Mark Wayne Clanton by driving said deadly weapon at or in the direction of Mark Wayne Clanton, then you will find the defendant guilty of the offense of aggravated assault with a deadly weapon as charged in count 1 of the indictment, and do not consider the lesser included offense as instructed in paragraph 5, and do not fill out the verdict form for the lesser included offense under count 1. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Darren Johnson, not guilty of the charged offense of aggravated assault with a deadly weapon, and next proceed to paragraph 5 to consider whether the defendant is not guilty or guilty of the lesser included offense of misdemeanor deadly conduct under count 1. 5. Lesser included offense of misdemeanor deadly conduct. Our law provides that a person commits the offense of misdemeanor deadly conduct if she recklessly engages in conduct that places another in imminent danger of serious bodily injury. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2023 in Bexar County, Texas, the defendant, Darren Johnson, did recklessly engage in conduct that placed another, namely Mark Wayne Clanton, in imminent danger of serious bodily injury by driving a motor vehicle at or in the direction of Mark Wayne Clanton, then you will find the defendant guilty of the lesser included offense of misdemeanor deadly conduct under count 1. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant, Darren Johnson, not guilty of the lesser included offense of misdemeanor deadly conduct under count 1. 6, count 2, injury to an elderly individual. Now, if you find from the evidence beyond a reasonable doubt that on or about the 21st day of October 2023 in Bexar County, Texas, the defendant, Darren Johnson, did intentionally or knowingly cause bodily injury to Mark Wayne Clanton, an individual who was 65 years of age or older, by hitting Mark Wayne Clanton with a motor vehicle, then you will find the defendant guilty of the offense of injury to an elderly individual as charged in count 2 of the indictment. If you do not so find from the evidence beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will find the defendant not guilty of the offense of injury to an elderly individual as charged in count 2 of the indictment. Our law provides a defendant may testify in her own behalf if she elects to do so. This, however, is a right accorded to defendant, and in the event she elects not to testify, that fact cannot be taken as a circumstance against her. In this case, the defendant has elected not to testify, and you are instructed that you cannot and must not refer or allude to that fact throughout your deliberations or take it into consideration for any purpose whatsoever as a circumstance against her. You are instructed that you must not communicate with or provide any information to anyone or receive any information from anyone by any means about this case. You may not use any electronic device or media such as telephone, cell phone, smartphone, iPhone, BlackBerry, iPad, tablet, or computer, the internet, any internet service, or any text or instant messaging service, or any social media platform, internet chat room, blog, or website, to include, but not limited to, Google, Facebook, MySpace, Instagram, Snapchat, LinkedIn, YouTube, TikTok, Twitter, or X, to communicate with anyone, any information, or receive any information from anyone about this case, or to conduct any research about this case until I accept your verdict. Written statements made by witness to investigators or other officers, or police reports made by officers and tendered by the prosecution to the defense for purposes of cross-examination are not part of the evidence unless introduced in evidence. Many times, statements and reports may be marked with an exhibit number, but are neither offered nor received in evidence. I can send only statements and reports received in evidence to the jury room. You are instructed that the statements of counsel made during the course of the trial or during the argument, if not supported by evidence, or statements of law made by counsel, if not in harmony with the law stated to you by the court in these instructions, are to be wholly disregarded. You must disregard any comment or statement made by the court during the trial or in these instructions which may seem to indicate an opinion with respect to any fact, item of evidence, or verdict to be reached in this case. No such indication is intended. You are instructed that the grand jury indictment is not evidence of guilt. It is the means whereby a defendant is brought to trial in a felony prosecution. It is not evidence, nor can it be considered by you in passing upon whether this defendant is guilty or not guilty. During your deliberations in this case, you must not consider, discuss, nor relate any matters not in evidence before you. You should not consider nor mention any personal knowledge or information you may have about any fact or person connected with this case, which is not shown by the evidence. You are instructed that you are not to let bias, prejudice, or sympathy play any part in reaching a verdict in this case. After argument of counsel, you will retire to the jury room, select your own presiding juror, and proceed with your deliberations. After you have reached a unanimous verdict, the presiding juror will certify thereto by filling in the appropriate forms attached to this charge and signing his or her name as presiding juror. You are the exclusive judges of the facts proved, of the credibility of the witnesses, and of the weight to be given the testimony. But you are bound to receive the law from the court, which is herein given to you, and be governed by that law. You all need to turn your cell phones off. In order to return a verdict, each juror must agree to that verdict, but jurors have a duty to consult each other and to deliberate with a view to reaching unanimous agreement if that can be done without violence to individual judgment. A unanimous vote means all 12 jurors must agree. Each juror must decide the case for himself, but only after an impartial consideration of the evidence with his fellow jurors. In the course of deliberations, a juror should not hesitate to re-examine their own views and change their opinion if convinced it is erroneous. However, no juror should surrender their honest conviction as to the weight or effect of the evidence solely because of the opinion of his fellow jurors or for the mere purpose of returning a verdict. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at her trial. The law does not require a defendant to prove her innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. In the event you have a reasonable doubt as to the defendant's guilt, after considering all the evidence before you and these instructions, you will acquit her and say by your verdict not guilty. Suitable forms for your verdict are attached to the charge for your convenience if you care to use them, but they are not intended to suggest to you in any way what your verdict should be, and you may or may not, as you see fit, make use of them. At any rate, your verdict must be in writing and signed by your presiding juror. Your only duty at this time is to determine whether the defendant is guilty or not guilty under the indictment in this cause, and you must restrict your deliberations to the issue of whether the defendant is not guilty or guilty and nothing else. After you have retired to the jury room, no one has any authority to communicate with you except the deputy who has you in charge. Do not attempt to talk to the deputy or anyone else concerning any questions you may have. Instead, address your question to the court in writing. If you want to communicate with the court, notify the deputy. Any and all communications relative to the case must be written, prepared by the presiding juror, and submitted to the court through the deputy. Respectfully submitted, Judge Stephanie Boyd, 187 District Court, Bexar County, Texas. Suitable forms are attached. State Are you prepared to proceed closing?
Yes, Judge.
All right, you may proceed.
It please the court. Defense. Ladies and gentlemen of the jury. Apology. Most of the issues in this case are relatively uncontested. The dates, the location in Bear County, the identity of the actor, the identity of the complainant, the age of the complainant, most of these are not strongly contested. What I suspect will be strongly contested, and what you'll need to discuss when you deliberate, are the mental state of the actor and whether her vehicle qualified as a deadly weapon. Now, ADA Galloway is going to discuss those issues with you later, but right now, what I want to focus on is one particular issue that I noticed during these proceedings, which is this question. Did a 78-year-old man throw himself in front of a Ford F-350? When you examine the evidence, when you examine the statements that the actor made to multiple officers and detectives, the statements of the witnesses, when you have examined all of these, I think that you will conclude that no, he did not. That he stood exactly where he had a right to be. He did not put himself in a position to be struck. He was struck. And when you make that conclusion, then you will need to decide what was the actor's mental state and what was the status of the vehicle that she used. Did it come to the level of a deadly weapon? When you have deliberated on all of these issues, I believe that you will render a verdict of guilty, both on aggravated assault of a deadly weapon and injury to an elderly individual. Thank you.
All right, defense.
So this case began with a 911 call that my client made after an incident. That incident was that she tried to park in front of her house. As you saw in the video, there was traffic coming by. That traffic is coming by because the corner that she's on is a very busy road. It is impossible for her to back into that spot. She went to park. He had put his trash cans out, or bins, or mulch bins, whatever you want to call them, on a Saturday. Not only when it doesn't get picked up, but when you're not supposed to do it according to city ordinance. So he put them out there to block her from parking in her own spot, even though it's in front of his house. He knew that she used that to park. Now, when she drove up, she stopped. She moved the cans behind her. She got back in and started forward. You don't see some big puff of smoke coming out. You don't, screeching and all that. None of that's available. She started to go forward. As she went forward, he comes running out of the house, grabs a trash can, and goes to the front of the vehicle, a moving vehicle that he knows is moving. Now, whether the vehicle hits him, the trash can hits him, it's impossible to say from the video. Impossible. But what I do know is that the police officers that showed up on the scene, they got it at least half right. They said, well, he was obstructing the passageway, and that's the way they wrote it up. They talked to all the witnesses on the scene. They looked at videos. They made their determination. And remember, they were on the scene. These detectives that came in later didn't think it was important to go to the scene of the crime. Even though they're higher paid, they're higher level, not important to go to the scene of crime. Why do that? I can read these reports in my own air-conditioned office. Why should I go out there? So they didn't go out there. But what they did do was they saw a video that was blown up bigger than it is on a small cell phone. Now, sometimes that's an advantage. In certain cases where there's robberies or we're trying to see somebody climbing in a window, that's an advantage. In this case, it led to what I call apparent error. Because the officers who saw that video didn't say anything about her turning her wheels onto the curb because they didn't see that. But what the detective saw, what Detective Myers told you from this witness stand was, I assume that she drove up onto the curb because I was looking over there and I saw her rim, then I saw the tire, then I saw the rim. So it appeared to me as if she drove up and then went back off. Now, had he gone to the scene, and you have evidence that shows this picture, he would have seen that what happened was not her going up on the curb, but the curb dipping down. And so he changed the write-up 11 days later. And he sent it to the state as an aggravated assault with a deadly weapon. He probably did it in good faith. I'm not saying he was trying to hurt anybody. He probably said, well, you know, this vehicle's moving, the tires are turning, and then they're turning back. You know, she's probably trying to hit this guy. But he didn't go out to the scene, so he doesn't know that. And so the big video showed the tire and the rim, but it didn't show that. And you don't see that unless you go out to the scene of the crime, period. So had he gone to the scene of the crime, we wouldn't be here today because they wouldn't have forwarded this case to the state, period. Now, once the state got it, they began developing more and more information, which is what they do. And they added in the injury to elderly. And then yesterday,
Judge, I'm gonna object to this line of argument. It's improper.
Sustained.
okay, so we have, at this point, we have an aggravated assault with a deadly weapon. We have an injury to elderly, both are felonies. Now we also have a misdemeanor deadly conduct. In all of these cases, there's some mental culpability required. And just like I talked to you in voir dire about a pen, it can be a deadly weapon. It's not automatically a deadly weapon. It depends on how it's used and the intent of the person. Right now, I'm not using it as a deadly weapon. I'm just using it as an example. In a similar way, when she pulled up carefully, moved the trash cans, got back in her car, started moving forward slowly, he comes running out and apparently pushes this bin in front of the moving car. And again, it's hard to see from that angle. From that angle, it's very hard to see exactly what happened. When he does that, she stops and she calls the police, which is exactly what she should have done. Now, you probably detected animosity between the two parties. And that's true. And some neighbors, for whatever reason, they just don't like each other. But she's not here to be found guilty because she doesn't like her neighbor, but because the neighbor doesn't like her. And it was obvious yesterday when I tried to question Miss Clinton, she wasn't answering my questions. She wanted to talk about allegedly seeing her husband flying through the air. The reason I objected is because she wasn't a witness to that. She wasn't listed as a witness to that. She never said she saw that until right then. And then when I asked her if she was in the house, well, I was in and partly out, partly in, partly out. Okay. I stopped questioning her because she wasn't answering any questions and she was shaking her head at me and getting angry. So I just let it go. Now, all of the police officers that had some part in this that were important to the state testified. The first officer said that there was an Andrew on the scene who you later saw come in here and say what he says he believed. But understand this, Andrew was never questioned by the other officers. And for whatever reason, that first officer on the scene who handed it over to Gapin, Officer Gapin, apparently didn't tell Gapin that. Because Gapin got up here and said there was no other witnesses. Nobody, just the people involved. That's what he said. So Andrew says he saw something. He's 2 houses down. Look at the angle that he's looking at. If you look at the picture of the Clanton's house, on the left is my client's house, on the right apparently is where Andrew was at the ground level. He's at a terrible angle to see what happened. He may have seen Mr. Clanton falling back at best, but he wasn't at an angle to see exactly what happened and when. And there's something else. For those of you who watch football, you can watch a game and they have slow motion forward, slow motion backwards, all kinds of trajectories of the football. I was watching one game and they even determined how much force it would take for the quarterback to throw the ball to get to this certain point when a receiver got there. And they detected that he threw the ball 2 pounds too light. 2 pounds too light. Now, as an observer, you can see all that on the computer, but the players that are in that scene, it's microseconds. They don't know exactly how much force. They don't know that. This video that we watched for 15 minutes is 1 second where this happens. It's 1 second where she has to make a decision and where he has to make a decision. He knows the car is already moving, but he thinks it's important to put his hand out in front of it anyway. Now, that's the case. The standard is beyond a reasonable doubt. That means that you've looked at all the evidence and that at the highest charge, beyond a reasonable doubt, she intended to crash this car into the man and use it as a deadly weapon. Then secondly, injury to elderly. It's not just is he injured, but did she intentionally or knowingly do it? It's another high standard. Then now we have in the misdemeanor, deadly conduct. Did she recklessly do it? There's a definition for reckless in here, which is very hard to understand, but part of it talks about gross deviation from normal conduct. Gross deviation, gross being large. So did she, when she was parking, was she completely reckless and exhibiting deadly conduct is what they're asking you to find her guilty of. I'm asking you to find her not guilty in all this because it was an accident. It wasn't a criminal event. The prosecutor started off by giving you an example of a road of 2 lanes that merge into one. And where a person is driving on one lane and they either yield or don't yield to the other car. Now, if you do yield, there can be a problem. I know that because when I was coming home from jury selection on Tuesday, on 151, as you get back towards Alamo Ranch, there's a bridge, goes into one lane. I see a truck coming up on me really fast. I know that we're going to one lane, so I slow down to yield. The problem was he slowed down at the same rate. So we're both yielding. So now I decide, okay, maybe I should just stop the car. So I hit the brake, stop the car, and he came forward a little bit. But then, I thought it was over because he passed me. I thought it was over. 5 miles later, I found out it wasn't over. Why? Because he attributed, based on my actions, criminal intent. He thought that I was trying to do something to him. Because when I came around the HEB, he was stopped with his blinkers on, which I didn't think anything at first, until I passed him. He turned his blinkers off and he gets right behind me, really fast, and he's right up on me. Now slow down, I pull over to the right, he pulls over to the right, he finally passes me, gives me the bird, blows the horn, and goes off, and I turn one way, he turns another. All because I yielded. So whether you yield or you both come forward, if you're doing the same thing at the same time, an accident. It just happened. But does that mean there's criminal culpability? Does that mean there's recklessness? Does it mean any of that? No. It just happened. It's an accident. It's unfortunate, but it happened. Now, this jury charge is really the law. I don't really like the word charge because it's kind of confusing, I think. I don't know why they ever came up with that. I would just call it the law. But it all requires some element, not just something that happened. So we now have this lesser included offense and misdemeanor deadly conduct. And that has to do with reckless, and again, that's gross deviation from the norm. And you can go through this, and I invite you to read it because it's the law, it's important. Now, the judge told you can't ask questions. What she meant was that during the trial, you can't question the attorneys,
2 minutes.
but you can question the judge when you're back there. And in fact, if you have a dispute over a certain piece of testimony, and you have to say there's a dispute, you can get the court reporter's record on that testimony, but you have to say that. Were the actions normal of Mr. Clanton? I don't know anybody that would went out there. I mean, he could have put the cans back after she parked, but that's not what happened. In any case, the standard is beyond all reasonable doubt, which is in there. I don't believe the state has met that. There's reasonable doubt all over this case. The officers who were actually there didn't believe that she did anything wrong. And that's exactly what we said. I ask you to deliberate. All of you have to agree on either guilty or not guilty. If there's a permanent disagreement, that's called a mistrial. Thank you.
If I could just ask.
Yes.
Respect your elders. Ladies and gentlemen, that is something that we all learned as children. And it's a notion that the defendant in this case, Darren Johnson, does not know or appreciate or follow. And we know that because Mark Clanton was a victim of aggravated assault with a deadly weapon and injury to an elderly at the hands of that defendant sitting right over there. And we're going to talk about the law that supports that. Ladies and gentlemen, Mr. Edelman talked to you a little bit about the elements in this case and the evidence that you heard and saw about. Aggravated assault with a deadly weapon. Now, as Mr. Edelman told you, most of these elements are conceded to. You've heard testimony from multiple witnesses about the date of the offense, October 21st of 2023. That's the date that officers went out there, that EMS was dispatched to Flairwood Drive, and Mr. Mark Clanton received EMS treatment for his injuries. In Bexar County, Texas, you heard multiple witnesses testify that Flairwood Drive is located here in North Bexar County, Texas. The defendant, you've seen her on the video, and we'll talk about the mental state. The bodily injury, you all saw the EMS records in State's Exhibit number 4 and the photo of Mark's knee that had an abrasion on it. The deadly weapon, we'll talk about in a little bit. And then count 2. Same elements, just the only difference is the deadly weapon is missing here and the 65 years of age or older. You heard Ina Clanton testify that Mark was older than that age. Now let's talk about the mental state. We talked about in jury selection that the law does not require you to be a mind reader, right? You are allowed to look at the circumstances and the facts that surround and determine the mental state. So in the jury charge, which is the law that governs you, intentionally is defined as a conscious objective and desire on the date of the offense. So let's look at that. It was the defendant's intention to move the trash bins, and she moved them from the side of the Clantons' property line into the Clantons' driveway. Now let's think about that. When you look at State's Exhibit number 5, which is the video of the offense, those trash bins did not need to be moved or touched by the defendant at all. That was a big street, and there were multiple ways that she could have gained access to that parking space if that was truly her intent. What her intent was on that day was to provoke Mark Clanton and get him outside of his home to engage in an argument with him. We can tell this by her demeanor on State's Exhibit number 5, which is the video of the offense. When you look at her, she gets off of her motor vehicle, she's swinging her arms, she's clearly angry and in a bad mood. And then once the offense occurs, once her motor vehicle collides with Mark, she gets off of her motor vehicle and starts shaking her finger at him. She's not concerned about whether he's hurt or not, and she shows no remorse whatsoever. She stands on top of him looking at him and then goes back to her home to wait on the police. And if you look at, this is on the State's Exhibit number 5, but you can clearly see those cinder blocks, which is the property line, and that the trash bins are on the left side, which is the Clantons' property. Now let's look at knowingly. That means the defendant is aware of the nature of her conduct or the circumstances that exist. I submit to you that she did, because in the statement that she provided to Detective Myers, she stated she knew that Mark was outside, she knew that Mark was concerned about the trash bins, and that they engaged in a conversation with each other. So she knew that he was out there and she saw him moving. But by the defendant's own statement, her actions are reckless. Reckless is defined as consciously disregarding a substantial and unjustifiable risk. So did she know that there was a big risk that this could happen, and did she disregard that? And I submit to you that she did. And we know this by her own statement, which she changed because on scene, she said, "Oh, Mark Clanton jumped in front of my vehicle," indicating that she was looking forward. But when she talks to Detective Myers 11 days later, she changes her story saying, "Well, I was actually looking back." Ladies and gentlemen, we've all been to driver's ed or taken a state driver's course. Nobody is pulling forward while looking back. And we talked about multiple reckless driving behaviors in jury selection, which included not paying attention, being a distracted driver, failing to keep a proper lookout, failing to obey traffic laws, and failing to take proper evasive actions. All of those are present in this case. We talked about in jury selection how testimony is evidence, and so we're going to look at the witnesses that you heard from, starting with Officer Kyle Gavin. Ladies and gentlemen, it's no secret, he did not do his job on October 21st of 2023. He had been on the force for less than a month. You heard his own testimony that he took that call for training purposes, okay? He only made contact with the defendant and Mark Clanton. That was his responsibility as the reporting officer to go and find the witnesses. So that's something that should be counted against him. He did not speak with Aaron Rodriguez. And he made the wrong decision. And how do we know that? By the evidence. Mr. Clanton was never in the street at all. He was up on the sidewalk. Furthermore, you heard from 3 additional senior officers that Mark Clanton did nothing wrong on the offense day. Now, Officer DeLeon was the first on scene. He handled passing the case off to the probationary officer. He separated the parties, and he did do his job correctly. He took statements from everyone that saw what happened, the defendant, Mark Clanton, and Aaron Rodriguez. And he also observed EMS treating Mark Clanton. Now, Aaron Rodriguez is probably the most important witness in this case because Mark Clanton is unable to be here today. But he observed the entire offense. And the account that he gave you from up there on the stand matches exactly the video evidence that we have in this case. He further testified that he heard the engine rev before the defendant took off. Ladies and gentlemen, that is evidence to her mental state at that time, which is intentionally knowing and at a minimum reckless. Aaron Rodriguez did testify that he saw the truck bounce up on top of that curb. Now, Detective Smith, you heard from him, and he testified that he received the report from Officer Gapin to conduct a follow-up investigation. And so he took many steps to conduct this investigation. He spoke with the defendant. He received State's Exhibit number 5 from the defendant. He reviewed it and he deemed that the obstruction report was unfounded. And he believed that a different criminal act had occurred, and he referred it to the safe unit for additional follow-up.
Your objection, you never said anything about crime definitely occurring, you said it might occur.
All right, ladies and gentlemen, you'll remember the evidence as you've received and remember the testimony of the witnesses. All right, you may proceed.
Thank you, Judge. You heard from Officer Sanchez. Now he makes the scene. He interviews Mark Clanton. He observed the injury to Mark Clanton, and he wrote an assault supplement to be submitted to homicide for further investigation. And then we get to Detective Myers.
3 minutes.
You heard his testimony. He broke down the video for us, and you saw how Mark Clanton never entered the street and how that truck came up on the curb. He testified, you cannot use physical force, such as the defendant did with her motor vehicle, to get what you want. He testified that in his training and experience, a motor vehicle can be a deadly weapon, and he is the one that submitted this case against the defendant. Now, he takes this statement from the defendant, and as I stated before, she changed her story after she had 11 days to think about what she wanted her narrative to be, okay? And she gives little pieces. She says the entire thing is staged. I will let you all be the judge of that because you have State's Exhibit number 5. And she says Mark jumped in front of her truck. There's no evidence to support that. Her rendition of what happened is not supported by the evidence in this case. You also heard from Ina Clanton, who defense has the audacity to get up here and speak ill of her after her husband just died a couple of months ago, and she has to come up in this courtroom.
I have a problem with that. I didn't speak ill of her. I simply stated what she said on the witness stand.
All right, ladies and gentlemen, the objection will be sustained. You're just to disregard the last statement from the state. You may proceed.
Ina Clanton is in a predicament where she has to come in this courtroom after her husband has died months ago and identify him because of the actions of the defendant. And you saw the photos that she took of his injuries. And she testified that he was 78 years old on the date of the offense. Ladies and gentlemen, State's Exhibit number 4 is the only evidence that we have from the mouth of Mark Clanton. And I urge you to look at that evidence when you go back to the jury room. And what's in State's Exhibit number 4 is that Mark Clanton sustained right-sided knee pain from being hit by a vehicle and an abrasion. And you will see the photo that was entered into evidence as well. Now, you all at this point are just deciding whether the defendant is guilty or not of the offenses that she's been charged with in the indictment. You've been instructed that you cannot let bias, prejudice, or sympathy play into your deliberations. This is something that we talked about in jury selection. And so if you feel like, oh, you don't think she deserves jail time, or you feel sorry for her, or you think she has mental health issues, those are things that would be considered in punishment, okay? You all swore to do a true verdict according to the law and the evidence. And I want to talk to you further about what makes aggravated assault with a deadly weapon. It's
30 seconds.
Bodily injury using a deadly weapon. This truck is a deadly weapon. It's a heavy-duty F-350. The lesser included in this case is not appropriate because the charge says that it is imminent danger, but the offense was completed. And that's what makes it an aggravated assault with a deadly weapon. Ladies and gentlemen, you didn't have an opportunity to hear from Mark because he's since passed away, but you need to render justice for him in this case. And the only verdict in this case that is appropriate is a guilty verdict. Thank you.
All right, ladies and gentlemen, I'm just going to have a couple of you remain Okay, who is here on Gerard Wade?
I have your honor. This is,
Where's your client?
Mr. Wade?
Needs to come forward. Oh, I'm doing fine. Have you conferred? Oh, it's a protein shake. Yeah. Have you conferred with the state?
Yes, I have. And this is our first setting for discovery. I'm going to have to do e-discovery, your honor. There, the rest not. Hopefully, it's gonna have this. One of my clients has told me about the real quick and better get to them.
All right.
All right, first setting.
So does the state, do you have the discovery uploaded?
Yeah, the answer to that question.
Okay.
What I normally do, your honor, is I get, 5 or
Huh?
6 cases, so.
Okay, all right, just a second. So on this case, Wade, do you know if all the discovery is uploaded?
Judge, I would have to have a minute to be, they're giving me the file right before, closing, and I can have an opportunity.
All right, so everyone, just give her a moment to see if all the discovery is uploaded, because we're not gonna come back to, oh, this discovery is not uploaded. So just step back for a moment. All right, thank you.
May we approach your honor?
Yes. So, Mr. Wade,
Mr. Wade?
so on this case, is all of the discovery uploaded?
Yes.
All right.
Thank you, your honor.
All right, so this is going to be your return date, and state at this next date, you'll need to be prepared to tender an offer.
Thank you.
So, Ms. Ferguson, have this come back on June 26th.
I'll have him sign the paper.
All right, thank you.
Thank you, your honor.
Yes,
Thank you very much, your honor.
you're welcome.
Thank you. It's gonna take me a minute. Thank you. I'm like, I know I took it up.
What did they do now?
Me too.
That's a law.
Yeah.
Thank you. May I be excused, Your Honor?
Yes, have a good one. Hey, when are they gonna open up the,
The Plaza Club for real?
yeah,
It's been open for 2 years or a year and a half,
but they
but-
brought back the chopped
Oh, no.
salad.
and I haven't gone, okay? And they even offered me to, they raised the rate like $30 a
Mhm.
month. But they give you like $40 or $50 food credit.
Mhm.
Even with that, I don't go. Why?
So,
Because it's just food. It's
And
not
where
Top
is-
Top anymore.
and where is it located now?
It's a couple of blocks down in that hotel.
What hotel?
Century,
Ah, okay. Oh, okay.
okay? It's on the top floor. I mean, it's beautiful. It's smaller than the old Plaza Club.
Mhm.
No chop chop. So you can't get the hell out of there. And
Yeah.
it's all food, you know, a little color here and a little color, that's what they want. Okay, that's not me.
No.
Give me meat and potatoes. Thank you, Your Honor.
All right. Have a
I'd
good
like
day.
to know though, if they ever do change, because each manager, they've had 2 managers already.
Ah.
Each manager I've told them go back to chop chop.
Ah.
And shows you how much weight I carry.
All right, who is here on Mark Lunsford? And is this a special?
It is, Your Honor, and I've reached out to him. I don't know where he is, but
30 minutes before we started closing, but he is in the building and I'll get it.
All
I'll
right,
wait.
so he'll come down and we'll
all
pick
right.
that up.
Safe to say.
Council, once he's here, just ask to approach.
I will, thank you.
Rogelio Elizondo,
Oh,
are you all ready?
Yes, I can approach it. I was gonna file the motion to substitute on that, Your Honor.
All right, well, the motion to substitute, you're conferring?
I'm not confirmed yet. I just pulled the file.
All
I need
right,
to get it.
so once you're all ready, let them know.
Oh, I called the file forward, Your Honor, I just wanted to inform the court. I didn't realize Mr. Rossiter was in the courtroom to
I can
inform
approach
that.
on the motion, Judge.
That's what I was gonna do.
I mean, are you appointed?
No, Your Honor, retained, but our office,
They signed the motion.
yes, Your Honor.
All right, who's the client?
Rogelio.
Rogelio, can you come forward, please? Sorry.
Sorry about that.
I have a copy.
And state you're not needed for this. Court is calling 2025 CR 002-998 State versus Rogelio Alfonso Elizondo Jr. Are you Rogelio Alfonso Elizondo Jr.? And if I could have counsel announce, you sir.
Mario Moreno, from the Gary Barton Law Office, Your Honor.
All right, can you raise your right hand, Mr. Elizondo? Do you solemnly swear and affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes.
All right, you can lower your hand, state your name for the record.
Rogelio Alfonso Elizondo Jr.
All right, the court is in receipt of a motion to substitute. Attorney Acevedo is asking that he be allowed to substitute in for the law firm of Gary Barton. Do you have any objections to that substitution? Are you requesting that substitution?
Yes, sir.
All right, thank you. You're excused.
Thank you, Judge.
Thank you.
Thank you.
And just have a seat. All right, are you all ready?
We are, Judge.
All right, if you'll come forward, please, and have your client come forward.
Mr. Lunsford.
All right, so in this case, has an offer been tendered?
No offer's been tendered, Your Honor. We're still in the early stages of discovery. I reached out to the prosecutor earlier this week about discovery. It hasn't been uploaded. It's a separate file. I provided a thumb drive to the state this morning and
Just 1 second. Excuse me, you all need to find a seat. All right, so here's the thing. We were here on April 7th and everyone said all discovery uploaded. And now I'm being told discovery not uploaded.
Well, I located some discovery that wasn't uploaded, so I compiled it for defense and I'll be uploading it this morning, next few minutes into this.
All right, so is there any other discovery
Not that
that
I'm
is
aware.
outstanding other than that upload?
Not to my knowledge, no.
All right. Norma,
Yes, ma'am.
recall this for June 26th. And at that time, state you need to be prepared to tender an offer.
Yes, ma'am.
All right, is there anything else?
no, Your Honor.
All right, thank you.
All right.
Thank you.
I just-
Yes, ma'am.
Sure.
That's a discovery plus tender offer. You're welcome.
Yes, she's just gonna hand me this paper.
All right, Ms. Abrams. why are we here on Nicholas Corpus?
Or your client's judge, we're requesting that his GPS monitor be removed.
All right, do you have a,
Yeah, just give me one.
thank you. No.
And that's what I wanted to do is make sure.
Hi.
Judge probation is just looking, I mean, not probation, the ADA, she just needs a minute because she's just looking this up.
Oh, okay. All right. So they're not ready, but I'll review those.
Okay, Judge, and you don't have anything on your email because I didn't get it together yesterday. Someone else got it together for me.
No.
But that's the court summary. When he was granted probation, just to give you a quick update, when he was granted probation, it was until further notice on his GPS. There's not been any violations. There's not been anything. He's been a model probationer. And I think some additional information is on there.
All right. Any objection to my reviewing the court summary?
None, Judge.
All right.
Just so I didn't file a motion. I just got a note that he was going to be here today, so I came on in.
All right. Sure. Who's here on Ed Vugan? Liao? Hello, where's your client?
He's right behind me.
Right
He's,
behind you, sitting down.
yeah, he's coming behind me. And Judge, I believe he's he's a first setting case. I want to know if I can have another pretrial conference and make sure I have all my discovery.
Right. So is there a blood draw in this or what?
There is.
And State, do you know if you have the blood draw?
It's in the file, Judge.
Okay. All right, Miss Ferguson. Let's see. Put this, is June 12th enough time for you to have reviewed everything?
Should be, Judge.
All right, Norma, put this for June 12th. That's going to be a discovery, and State, you need to be prepared to tender an offer on that day.
Yes.
All right, is there anything else?
No, Your Honor, thank you.
Thank you for dressing appropriate for court. Once you sign the reset form, you're excused.
Thank you so much.
You're welcome.
I'll get a recess. What's happening? She back there?
Oh, okay.
The first come, first served.
I got it. I got it.
The preservation.
That's a word I will say.
And David, your client was late, so he can't be late next time.
Jeffrey.
And David, It has on here Spanish. She's not a do you need an interpreter?
No, I don't know.
All right, thank you.
Not for one. Thank you. Thank you. All right, is there any following in the back office? No, just. Well, it says the jury's gonna bus. Yeah, no. If they bus. They bus? No, everybody, oh, you're good.
He's got more in. That's the. I have. Judge for a reset.
Are you all ready on Nicholas Corpus or no?
So we need to be the right person to ask,
Okay.
get us prepared. It's for Vermina, sir.
You need some?
Yes, Patrick.
All right, Mia Hermeo Herrera. Have you all conferred with the state?
They're still waiting for her to provide that.
All right.
And in addition, Your Honor, it's just a motion to step on, unless they have no issue.
And they're not ready on this. And they're not ready on that.
In this Trevino, if that makes a difference. No.
Yes.
Um,
Are you all ready?
no, Judge,
All right.
they're just reaching out to the complainant again.
Okay.
But I just wanted, may I be excused and I can
Sure.
come back?
All right, who is here on Aaron Joseph Mendez Trevino?
I am, Judge.
And where is he?
He's in the back row.
Come forward. All right, today is plea deadline date.
I believe that's the case, Judge.
All right, do y'all want a jury trial?
We need a setting. We're still hopeful it can be worked out, Judge, but apparently I can only deal with Jason on the offer for PTD. We had gotten a packet for him today, so I'll get that presented to him in the next few days when he's back, and we'll see if that can resolve it, but otherwise we can get a trial setting unless you want to give us one more pretrial, whatever your preference.
No, it's gonna be a jury trial setting. Ms. Ferguson, set this for jury trial setting in June, please.
June 16th.
No. Can we do it the week of June 23rd? All right, let's put it at June 23rd.
Yes.
All right, thank you. Once you sign the reset form, you're excused. All right, and I need an acknowledgement of discovery signed as well.
Yes, Judge.
Thank you.
Update on the interpreter.
All right, Marlon Daniels.
The interpreter almost here. Keep an eye out for it. So like as soon as one interpreter's here, we're ready to make our announcement to get the reason. For Dominguez.
So negative comments about his jacket, please, Judge.
And
Just trying to push my buttons,
probably Dominguez.
But you all are family now, so I won't say too much about the jacket.
Thank you.
All right, so my understanding, blood discovery was received by April 9th. That's the last word I was told, that you all would have it, so I'm assuming you have it.
I believe we do, Judge. Mr. Sharman is stuck in another county in district court there in Kerr County and asked me to cover for him this morning. I think you wanted the state to tender an offer, which they did do today. So we received an offer. I'm going to pass that on to Mr. Sharman.
All right. So your jury trial is going to be June 16th. Yes.
If you can have the offer today.
Oh, no, he can still enter into a plea on June 16th. Is that good for everybody or no?
I guess I just asked the court for a deadline.
June 16th?
Could we have a plea deadline there and then a jury trial beyond that, Judge?
It's going to be whatever that judge says.
You're out that week?
Yes, I am.
Okay.
Judge, just because, so the blood discovery, it was tendered after, so Judge Angeline was here at the last study. And we did have the blood discovery, it was supposed to be left at the fourth floor window. And then it wasn't there, so I personally gave it to Mr. Sharman, so. And then. Whatever.
All right. Jury trial and plea deadline date, June 23rd.
Will you be here then, Judge?
Well, I mean, God willing and the creek don't rise, but if I'm not here and something happens, then it will be another judge. You know what Cornelius, and I don't know if you remember Grantley William Arthur Boxhill. Grantley Boxhill was an investigator I would use. Everybody called him Box. And so I would never take vacations as a defense attorney. I know how maybe you were the same way.
It's tough to be gone more than.
I would always call my clients the day before and remind them that they had court. I would still talk to my mom on the phone every day, but I wasn't visiting as much. And so Cornelius and Box said, Stephanie, if something were to happen to you and you were to die tomorrow, do you know what would happen? I'm thinking they're going to say something. The courts are going to shut down. People are going to be beating themselves saying, oh my gosh, she was just she was too precious for this world. He's like, I would be very sad because you become like a sister to us. But what they're going to end up saying is, all right, this attorney has died. She's the next person to take their cases. So if I'm not here, if something were to happen to me, you know what they're going to say? That's a shame. Who's the next judge who's stepping up? And they're going to bring in visiting judges until the governor decides what he's going to do. So God willing, I may be here. If something happens and I'm not here, it could be any judge. So the plan is for me to be here. So your jury trial date is June 23rd, and that will also be your plea day.
Thank you, Your Honor.
All right, thank you. Yes. Because I'm supposed to be speaking at an event for continuing legal education for people. So we'll see if I can impart some knowledge.
I would say it is.
I'm just trying to take my time.
It was.
Okay.
Like it happens down there. Are we in the queue? All right, thanks. I wanted to.
All right.
So apparently. Perfect.
Like the dispositions. Right, 'cause she's-
All right, who is here on Maciel, I'm sorry, Dominguez Serna?
Carlos Ramirez for the defendant, Your Honor. So he's Spanish speaking interpreters here.
All right, and you're on that side.
Yes, Your Honor.
All right, let me find him on the docket.
He's on page 3, there's a spot.
Thank you. All right, so today is plea deadline date. Are you all entering into a plea?
So I confer with the prosecutor, Your Honor. So she did say that we're applying as PTD eligible. So we'll be getting a PTD application. We're requesting a 45-day reset to see if he's going to be accepted into the program.
Yeah, we're recalling this on June 16th for jury trial. If he's not accepted, then he's going to be in jury trial.
So Your Honor, I will not be here. I will have a vacation letter on file for June 16th. I will not be here on June 16th. Vacation letter is on file.
Oh, when are you going on vacation?
So it's going to be from the 13th to the 20th.
All right, Norma, set this for jury trial June 9th. All right, and I need an acknowledgement of discovery. Oh, it has been signed. So your jury trial is going to be June 9th.
Sorry, Your Honor.
June 9th.
So
So there's going to be a PTD. It needs to be done before or on that date. If it's not, he'll be going to jury trial.
yes, Your Honor. We do get this application in no later than 24, 48 hours. Can we get that to fall off the docket from June 9th?
We'll see. He needs to be here on June 9th, though.
All right, understood, Your Honor. Thank
All
you.
right, thank you. Thank you.
Morning, Your Honor.
Good morning.
Thank you very much.
You're welcome.
Mr. Wyatt. Yeah, you can get. It's just that we have. The holding area. For capacity.
Jonathan Dreamer.
Judge.
Hello. All right, so are you all asking for a jury trial?
Yes.
All right, Norma set this on June 16th.
Yes.
All right, once you sign the reset form, you're excused.
Thank you.
That's your jury trial date.
Thank you.
How are you? Oh, it's first of hour.
We can take.
Thank you.
Open up the. Work class. Oh.
Yeah, okay. All right, thank you. All right.
1:35.
The whole week. Is it the whole week? Or just? No.
Angel, Rhonda. Come forward.
Good morning, Your Honor.
Good morning. So do you have the discovery on this case?
I believe we do, Judge.
Was the state able to tender an offer?
Yes, we just received one today.
Sir, how old are you?
25.
All right. And are you a citizen?
No, resident.
All right. Do you need an immigration attorney to speak to him?
We will, Judge. We have one in our firm. I don't need that.
Okay. All right, then, your plea deadline date is gonna be June 12th. If an agreement is not reached at that time, your next setting is gonna be a jury trial date.
June 12th, you said.
Yes. Any questions? All right, do you have any questions, sir?
No.
No.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome.
Trial certificate. Oh, sorry. Ollie, Kelly, the NTR. Thanks. You need two? Thank you. You got all that.
Rogelio Elizondo.
Suspense.
All right. Have you received an offer?
It looks like there was an offer in the file to the previous attorney judge.
Mhm.
I conferred with Ms. Galloway and let her know that, once I had an opportunity to download all the discovery and reviewed it, I'd get back with her and confer again on it.
All right, Ms. Ferguson, on this case, reset it for, how old are you? All right, Norma, reset this for June 12th for a plea deadline date.
Yes.
All right, once you sign the reset form, you're excused. Thank you for dressing appropriately for court.
Thank you.
You're welcome.
Thank you, Judge.
You're welcome.
I had tried to come yesterday and approach you on it, but I know you were in the middle of the trial.
All right, thank you. And I'll need an acknowledgement of discovery signed if it hasn't been signed.
Even though I haven't downloaded it.
Well, just check to see if the other attorney has already signed it.
Okay.
Okay, thank you.
It's on Elizondo. 12, right, Your Honor?
Yes.
12, about a plea deadline. They signed it on 4/22, Your Honor.
All right, thank you.
And if I need to sign another one, I'll come back and sign another one.
All right, thank you.
Thank you, Judge. Whenever you're ready. Thank you.
Oh, thank you.
Hi,
Hi, Judge.
Angelo Rosada. Who's the attorney for Angelo Rosada?
Judge, that's.
All right. Thing.
The supplemental report is the last page, Judge.
All right, Mr. Rosado,
Yes, ma'am.
the problem is you keep testing positive for drugs.
Yes. Yeah.
Did you want to say something?
Yes, Judge, I just wanted to give you a quick overview real quick. He has been on probation since May of 2024. He was granted 2 years deferred adjudication. He has completed the intensive outpatient treatment. He did test positive for cocaine on March the 28th of this year. Previous UAs were negative, just that one positive UA. After speaking with, they did a updated TAP because of the positive, and he's already completed intensive outpatient. The revised TAP per standard is for him to do static. After speaking with Mr. Rosado, it appears that there were some conditions that were supposedly implemented when he was first given probation that we do not believe were implemented, to include the urinalysis hotline and sober support meetings. So I did speak with him in regards to everything. He does have some information he wants to explain to you. He is not opposed to doing intensive outpatient treatment again. I do propose that he does the sober support meetings 120 and 120 days and be placed on the urinalysis hotline for 90 days.
Right, so here's the $1 million question. If you're drug tested today, are you gonna be clean?
Yeah.
All right, let's do a drug test, then I'll figure out what I'm gonna do.
Okay, Judge.
And if you'll send him to felony drug court to do the US.
Okay, Judge.
All right, thank you.
I think we got one.
Who is here on Ollie Kelly?
President, Your Honor.
Where's your client? Are you all ready to proceed on the motion?
Yes.
All right, court is calling 2025 CR 00123. I'm sorry, 1273W. I'll repeat that. 2025 CR 00123W, State versus Ali Joanna Kelly. Could I have parties announced?
Megan Galloway for the state.
Roberto Vargas, the defendant, ready to proceed, Your Honor.
And are you Miss Kelly? Are you the same Ali Kelly who was placed on deferred adjudication in 2025 CR 0012773W for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on February 5th, 2025 for a period of 2 years? Is that you?
Yes.
All right, state.
Violation of condition number 5 in Bexar County, Texas. The defendant, Ali Joanna Kelly, did then and there fail to report to the supervision officer as directed for the months of March, April 2025, in violation of condition number 5.
How do you plead to that? True or not true?
It's true.
Okay. All right, did you understand by pleading true to that, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation of condition number 5?
Yes.
Court will find violation of condition number 5 true. Is there a proposed agreement?
There is, Your Honor, we are asking you to deny the state's motion to continue the defendant on her community supervision, but to alter and amend her conditions to include an updated top evaluation, mental health evaluation, the ISP program, and then weekly reporting until ISP.
All right, can you raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God? All right, you're gonna have to keep your voice up. You can lower your hand, state your name for the record.
Joanna Kelly.
All right. So why did you not report?
I've been homeless and I'm not from the San Antonio area and I'm requesting for like assistance with bus fare
All right, where are you from originally?
from Texas.
I'm sorry.
Beaumont, Texas.
So what brought you here?
Moved here. I worked here. I lived here for a while, but I fell on hard times.
All right, and when you say you worked here, what were you doing here?
I worked at Jewelry Closet, Conduit Closet,
Doing what?
Jewelry Closet housekeeping, Conduit Closet as Verizon telemarketers.
All right, so did you come here for work? I mean, what's the reason why you came to San Antonio? Why not
I came here to
somewhere else?
They were within this last year, so following hard times.
No, I mean, did you come here by yourself?
Yes. Myself.
All right, so you just came because there was a job here?
Change. I just need
All right, do you have children?
one,
Age?
20,
And how old are you?
38.
And so is all of your family in Beaumont?
Yes.
All right, so how often have you been using before you were arrested?
I've been trying to get back into workforce.
No, you're not listening to my question. you're on deferred adjudication for possession of drugs.
Yeah, and since then, I've been doing everything that I possibly.
So
could to get it
before,
to work.
I'm talking about before, how often had you been using?
Oh, before?
Mhm.
Recreational.
Okay, here's the thing. I was not with you. So I don't know how often you were using. So that's what I'm trying to, I was not with you.
I'm not really sure. I wouldn't say that it was an everyday thing.
And what were you using?
Smoking weed.
And what else?
I guess you would call it methamphetamine.
No, I mean, I wouldn't call it anything. I wasn't with you. That's what I'm telling you. Here's the thing. You're on deferred adjudication. I could send you to the state jail facility for 2 years. So what I need you to do for me is answer the questions that I'm asking and be honest. Because it appears that the state and the defense want to continue on probation. When you're on probation, this is a contract with the court. I do not have to follow any of their recommendations. So I'm trying to figure out what's going on with you. And if you're going to be dishonest with me, that means that there's nothing I can do to help you. And maybe 2 years is what you need to open your eyes. I was not with you when you were using drugs. I don't know what your idea or your definition of recreational use is. So now that we've said that out the way, I'm gonna pretend like I'm just now meeting you and I've just sworn you in. So how often were you using?
During the week, like once a week. But
And what were you using?
weed, marijuana, and methamphetamine.
And when did you first start using meth?
2021.
And is all of your family in Beaumont or here?
Beaumont.
All right. All right, I'm gonna give you a choice. I can continue you, but if I continue you, you're gonna have certain conditions. You're gonna remain in custody until a TAP evaluation is completed. You're gonna follow all of those recommendations of TAP. And I'm gonna give you some more conditions that I see that the previous judge did not give you. So, or I can revoke you and I will sentence you to 1 year in the state jail facility. What do you prefer?
Rather do first option.
All right, and probation, is that your recommendation?
Yes, Judge.
All right, the court will deny the motion. Alter and amend conditions. And I'm sorry, they're wanting a mental health evaluation. Have you ever had any mental health issues? Have you ever been on medication for mental health?
No.
All right, the court will deny the motion, alter and amend conditions. There's going to be a TAP evaluation in custody. That's to see what drug issues you have. It's basically a resume for your drug use. Yes.
Judge, in speaking with Ms. Kelly briefly, she did say that she was getting some medication for anxiety to help her sleep, and she's dealing with a bit of depression. I would like to get that mental health evaluation.
All right, there's to be a mental health evaluation in custody. There's going to be 120 sober meetings and 120 days upon release.
So
How far did you go in school?
I graduated with honors, cum laude.
All right, is this college?
No, that was high school, and I did cosmetology.
All right, there's going to be 200 hours community service restitution. Those hours will be waived if you obtain some sort of trade school certificate or complete some higher level of education.
Massage therapy. That's my next venture.
Sorry, what?
Massage therapy.
Okay. And there's to be weekly reporting upon release. And proof of employment within 45 days of release, no employment as a home health care provider or with minors. And do a referral to felony drug court. And that will be in custody. Is there anything else that you need from the court to be successful?
Transportation assistance with bus fare.
All right, if you will talk to them, I know there are different organizations in the city that will give you a free bus token, but it's not forever. All right?
Yes.
Anything else that you need help with?
Some housing assistance.
All right, you'll need to talk to probation about that, but you need to be honest with felony drug court If you're honest with felony drug court, they'll accept you into their program and they can help with certain needs you may have. All right, probation, is there anything else? All right, we can go off the record. In this court, to be successful on probation, communication is key. If there's an issue, let your probation officer know. If you feel they're not addressing it, you can always come back to the court. But one thing you should not do in this court is disappear. You understand? There is not a problem with picking up the phone and calling somebody to tell them what your issues are. You understand? All right,
Is
good
there
luck to
a person in particular that I would have direct line?
They'll let you know it's your probation officer. All right, good luck to you.
Hey, Judge, may I be excused?
Yes.
Move over. English, Spanish.
Yes.
Not.
Want to do that again? First, we're ready on morning. Morning. Tomorrow.
Yes. Sure. And also, I told Deputy Laura to bring back Anita Garza's client because there's something he wanted to tell me. Yeah, so. Lori Valdez. Good morning. Where's your client?
She is in custody, is not here.
Okay, they'll get her here.
She was still at the jail, as far as I understand.
Okay,
I
they'll bring
just-
you can zoom in, but I require that client third present. All right,
Okay.
just let them know and they'll zoom her in.
All right, from the jail?
Or either you can zoom in if they're bringing her over. Just speak with Deputy Laura.
See you.
All righty. All right, thank you. You can appear by Zoom. Justin, Heather,
Hello again, Judge.
hello. All right, where are we on discovery?
Discovery is in, Judge. The state has allowed us to apply for the mental health PTD court on this young man. So that's what we're gonna request. I've already spoke to Ms. Ferguson about it. She's gonna notify the mental health court staff.
All right. All right, Ms. Ferguson, this is mental health. I'm assuming we should have some information by the 16th. Is that possible?
Yes, ma'am.
All right, so we'll, yes.
I'm gonna be out of town that week. Can we do it the following week?
We can do it June 12th.
I'm leaving on my road trip out west, so I'm sorry, I am leaving on the 11th. And I
We
won't
can
be
put
back
it-
until the 23rd,
All right, we can put it on the 9th.
Monday the 9th?
Yes.
Sure, okay.
All right, Norma, recall this for June 9th. Hey, you can play the song On the Road again. Or if your car is a pink Cadillac, you can play Aretha's Pink Cadillac.
Black Cadillac, yeah.
Paint it pink. Have somebody do a rap on it. All right, let me find him on the docket. Just one moment.
Yes, ma'am.
All All right, thank you. All right, so you'll be back on June 9th.
Yes, ma'am.
Once you sign the reset form, you're excused.
Have a seat. I'll bring it up.
All right, Deputy Laura, if they haven't been transported, his client, just see if they can have them by Zoom. If they haven't already been transported.
They haven't judged, they need to send her back and bring some in, especially like the jail.
All right, so just see if they can have his client by Zoom.
Okay, Judge, real fast, on that other issue I was talking to you about earlier, the getting the guy out on IOP and stuff.
Mhm.
Bashan, I believe, prepared the paperwork and she was gonna present it to you to sign.
Okay, all right, thank you. Who is here on Adam Keith?
I have judge.
And where's Mr. Keith?
Judge, it's my understanding that Mr. Keith was not transported. They're over capacity, so I want to see if I can get him recalled.
They'll need to have him appear by Zoom.
Judge, I'm not sure how long that's going to take, and I have other plans this afternoon.
All right, just ask them to have him appear by Zoom.
See if they can do it by about 10 minutes.
Okay.
All right, who's here on Adam? Oh, I just called that. Luis Brasinho.
That's fine, Judge, we're ready.
All right, thank you. What question? Okay. Just one moment. Let's see what this question is. I'm sorry, just give me one moment.
No problem. Where are you now? Nothing that. But where is it local? What is it local? What do you mean? Like. Where is it? It's in Castle House. Okay. I didn't.
All right, Mr. Porter. And state, this is the juror's question. And if you all can review that. All right. Who are the attorneys on Luis Briceño? Who's the attorney for the state? You think it's, okay. Are you ready to proceed or you want to answer the question?
I've had a chance to read it, so I'll get Mr. Porter. So,
The basic answer.
All right,
Yeah, hold the line.
all right. Okay, is Ms. Johnson here? Counsel, if you just step to the side for 1 moment.
Absolutely.
Could I have the, that, what's printing?
Not much for you. I hadn't heard about that.
Oh, yes.
That's insane. Thank you.
And,
That's insane.
oh, it is. Johnson, please. All right, we're on the record in 2024 CR 2675 State versus Darren Johnson. Could I have parties announced?
I need to wait for the state.
And Ms. Johnson, if you could come forward.
William Davidson for Miss Johnson and Robert Porter.
For the record, Ms. Johnson is present in court. The court has received the following question from the jurors. What is the meaning of gross by the law? Any objections to the following supplemental charge? With reference to your inquiry, you have all the evidence before you. Please continue your deliberations. Any objections, state?
No objection.
Any objection, defense?
No, Your Honor.
Any objection to the court sending the question, the answer to the jury?
No, Your Honor.
All right, thank you. All right, we're on the record in 2024 CR 011184 State versus Luis Briceño. Can I have parties announced?
Megan Galvin for the state.
Roberto Ambrosino for the defense.
And are you Mr. Briceño?
Yes, Your Honor.
All right, you entered a plea on April 17th. According to the plea bargaining agreement, the state is recommending deferred adjudication. There's to be restitution to the complainant. The court requested that a MIC evaluation be completed. Have both parties had a chance to review the evaluation that has been completed?
Yes, Your Honor.
Yes, Your Honor.
Any objections?
No, Your Honor.
All right, any witnesses, state or defense?
Just argument, Your Honor.
All right, the court will hear argument.
Judge, I just want to ask the court to follow the plea bargain. Essentially, Mr. Briseño was in a very bad place, mental health wise, and struggling with addiction to some extent. In December of 2024, he entered New Choices Treatment Center, where he did a 60-day inpatient program and has been doing outpatient since then. He's in the aftercare program where he's working. He's still there as we speak. He's basically been in some type of treatment since December. He's doing really well. I think there was mention in the mental health evaluation about getting him on the proper medication, which he is now on. He reports that it's really helped him and he's doing well. I'd like to ask the court to follow the plea bargain. If the court is inclined, I know the TAP evaluation recommended that he do outpatient treatment. It's essentially what he's doing. I don't know if the court wants him to do anything additionally, but maybe just to order him to continue what he's doing might be the most useful thing on top of AA and NA classes. But for all those reasons, I'd ask that you follow the plea bargain.
All right, probation. With regards to New Choices, if probation is able to evaluate whether New Choices is equivalent to outpatient treatment with probation, if you deem it equivalent, then the court will accept his treatment with New Choices. And you'll need to sign a release. Do you understand?
Yes, Your Honor.
How far did you go to school?
I got my high school diploma.
All right, so what are you planning on doing with the rest of your life?
I'm planning on, once I'm out of sober living and I have enough money, I'm planning on finding my own place to live and then going back to college and completing college.
When I met Mr. Briseño, I believe he was enrolled in is it Northwest Vista? San Antonio
no,
College.
And do you have any children?
No, Your Honor.
All right, that's a good thing. Because you need to make sure that you are in a good place before you bring other people into the world, okay?
Yes, Your Honor.
All right, this is what the court is going to do. Okay, sorry. There's a $2,500 fine that will be probated. Affirmative finding of deadly weapon, 8 years deferred adjudication. If you complete everything successfully and you're doing well, I'll consider early termination.
Would the court also consider deferring the deadly weapon finding? There's no history. Been pretty proactive since things.
He's to continue with treatment with New Choices and continue with sober living. You're to sign a release with probation so they can keep an update on how you're doing with New Choices. There's to be restitution, if any, and no contact with the complainant. We'll set that for a restitution hearing. Let me see. State, on this case, is there a specific date you want set to determine if there's any restitution? All right, so we'll put it for I'll put it for July 3rd. Is that not July 3rd? I'm sorry, July 10th. Is that good for you, counsel?
So I'm actually out the 10th or the 16th.
Ah, okay.
Could do the 9th.
I could do the 8th or the 7th.
The 8th is.
All right, Norma, this is going to come back on a restitution hearing on July 8th. And I don't want to interfere with your client's sobriety or being at the sober house, so he can appear by Zoom for that restitution hearing. There's going to be regular reporting by Zoom or in person, regular random UAs, proof of employment within 45 days. There's to be no employment as a home health care provider or with minors. There's going to be 250 hours of community service restitution. Those hours will be waived if you obtain some higher level of education or a trade school certificate. There'll be 90 sober meetings in 90 days. And continued mental health treatment. And field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, did you review the document? Let me see if I have it. Entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney. Did you understand it and sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, good luck to you. We can go off the record. In this court, to be successful, communication is key.
Yes.
If you have an issue, let probation know. If you feel as though your medication is not right, let probation know. If you feel like you're gonna use, if you feel like the walls are closing in on you, let probation know. If they're not addressing it, you can always come back to court, okay?
Yes, Your Honor.
All right,
Thank
good
you.
luck to you.
Thank you.
You're welcome. I call it, yes, an order of
In fact,
appearance. So
ready.
You need to make sure that they've given me the file.
For corpus, okay.
Yes.
We are officially ready for corpus. She said, make sure she's.
Thank you. All right, and Norma, on that last case, make sure that it's in there for a restitution hearing on July 8th.
Yes.
Thank you. Who is here on Hector Aguilar?
Judge, I am, but we need, that's a reset, we need an interpreter.
All right. Who's here on Jalissa Saranil?
Hi, your judge.
Morning.
Good morning.
Thought about it the other day. On Netflix, they have that, it's a documentary on the guy that would hid that treasure. Everybody's looking, I remember you always told me about that
Yeah.
long time ago.
Okay, have you seen that? Isn't that
Crazy.
It was crazy.
It was cool though. I mean,
We were watching it and we were like, what? And then there were parts where I'm like, oh, I don't need to see that.
right?
All right, let me see.
Yeah. Judge, on this one, this is our first setting, right? And so I think we'll follow a speedy trial motion. Should be dispositive, hopefully in about 30 days or so, if we can get a hearing for that. It should take 30 minutes.
Well, have you all, do you have all discovery?
I believe I do, Judge, yeah. This is a 3-year-old case.
A 3-year-old case?
Yeah.
That'll count against us, even though it wasn't in our court and this is your first setting.
Right.
So. All right, so what I'm gonna do then, if you want to put it on the trial docket for June 16th, we can.
Hey, a minute, I'm gonna be here, Judge, and then. Sure, I'll be here June 16th.
All right, jury trial, June 16th.
But I was gonna see if I could get my motion for speedy trial heard on that day.
Oh, it can be heard on that day.
Okay, that's what I'm.
Yes.
Sure.
All right, thank you.
Thank you, Judge. Have an excuse?
Yes, you're welcome.
Thank you.
And counsel, if you want the motion heard sooner than that, just let the court know and we'll put it on the docket.
Thank you, Judge.
All right, you're welcome.
He's in the jail. He says there's not enough room over there.
He will be on via Zoom at 11:30.
Well, okay.
Thank you.
Do you have a monitor for me to use?
Hector Aguilar.
You still need an interpreter for that, Judge.
All right, they're not.
Or you got a monitor?
I have a Lynn Moore if you want to take that one.
Monitor.
All right, we'll get to it. Ethan Rosales.
I can go home. Think that in. They all say they don't have space.
All righty.
So, Judge, I got a new offer on this case. I'd like to see if I can recall it tomorrow for a plea so his dad can be here, but I think it'll be a plea in the morning.
All right, Ms. Ferguson, this is coming back tomorrow for disposition.
On Ethan Rosales.
Ethan Rosales. All right, once you sign the reset form, you're excused.
Thank you.
I'm sorry, what? Just give me one moment and I will see.
You background. You may have, I think.
Corpus. Nicholas Corpus. And then do y'all have a file on Keith Adams? Let's see if I still have it. All right, Mr. Corpus.
Yes, Your Honor.
All right, what are we here for?
Judge, we're here for probation. Has requested that Mr. Corpus be released from his GPS monitoring. He was placed on it for an indeterminate time when he went on probation. He's been on it for almost 14 months. And Probation has described him, and I'll let probation speak.
Judge, we have absolutely no concerns with Mr. Corpus. He has had no violations. He reports when he's supposed to report. No violations with his GPS monitor and or with his UAs, Judge.
All right.
And he's doing the classes as he's needed to do and everything, Judge.
All right. Am I understanding he's completed the family violence course?
Judge, I don't have the court summary in front of
I'm
me.
sorry, I have it. I have that he completed lifetime recovery, batterers intervention and prevention program. All right, you want to raise your right hand for me? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I swear.
All right, you can lower your hand, state your name for the record.
My name is Nicholas Isaiah Corpus.
All right, what did you learn from the batterers intervention and prevention program?
Just to keep your hands to yourself and
That's what I tell everybody, keep your hands to yourself, right? So how do you spend your days?
so I work Monday through Saturday for ATS Transportation Company.
Mhm.
And then on Sundays, I do side jobs, painting cars, motorcycles, boats. Pretty much just work all the time. It's kind of hard for me to keep money in my pocket.
All right, so you know that you're not allowed to have any contact with the complainant?
Yes, Your Honor.
All right, state, were you able to contact the complainant?
Where she does have significant safety concerns still, since the GPS monitor was placed on him. She can't confirm, but the person that she knows is the friend of this defendant viewed her profile on LinkedIn. Additionally, on April the 24th, the defendant picked up what is currently an at-large misdemeanor VPO for two attempted contacts of the victim by phone and then Facebook messaging as well. Contact with the victim.
Yes.
Judge, I can't have my client make any statements about that allegation. I can tell you that I've had a lot of contact with Mr. Corpus. I don't believe the allegation. At the very crux of this, before we even did the plea, he didn't want anything to do with her. I don't believe for a second that he's reached out to her. And today is the first time I've had any information given to me about these charges. There's no warrant at this time.
Okay, so this is what the court is going to do. The court was really inclined to lift the GPS, but I want you to have a chance to see what they're talking about with this, what they're saying is an at-large violation of protective order. So how much time do you think you need to look in that and state, when can you give the information to the defense?
Could probably put the court order right now.
All right, so then what we'll do,
And Your Honor, if I may, no report's been made to probation. So she knows he's on probation. She didn't ever call probation to make any complaints.
okay. All right, so here's the thing, and I want you to understand where I'm coming from. When people are on probation, I have to make sure that the public is protected, right? Now, I'm not saying that the violation of the protective order that they're saying is in place that you violated. I don't know. I have zero information. Right now, I have as much information as your attorney has. All I have is this is what the state has said. I'm not taking what they said as true, but before I release you from GPS, I want to get some more information about that. And you'll need to have the complainant come in on this next date that I'm giving you. And defense, if you'll let me know what date is good for you and your client works, your client can appear by Zoom.
Yes, Your Honor. And Judge, I think, is he on tracking only? I believe, I don't. Probation?
If he's not on tracking only, I'm going to put him on tracking only and state you'll know where he's located.
Judge, in addition to that, one of the big concerns is this is a big financial pressure on him. He also helps his mom. I have a letter here that she's written. He's not able to help her with as much as she needs because of all of his costs. And so, as you know, the GPS is very expensive. Is it possible for the court to waive those fees?
I will tell you this, I will ask that fees be waived, and you know what they're going to tell me? It's a third-party contract. I can't waive the fees, but I'll put in there to waive or defer fees. And if he's not on tracking only, I'll put him on tracking only because with
Yes, but are you on tracking?
How do I know what is tracking on you?
tracking is you can go wherever you want to go, but you keep the GPS on and they'll know where you are.
Yeah, I also have a time limit from 5 a.m.
Well, on this one, you won't have a time limit, but the GPS device will be able to report where you are. So if you're anywhere near the complainant, the GPS is going to know. You understand?
I think that's what I'm on.
All right, well, just to make sure, it's going to be tracking only. And counsel, how much time do you need? The state said they'll print out this information for you. When do you want it called back?
Well, Judge, I can look over it today. I'm obviously not retained on that case yet,
Okay.
but, I can look over it today. I mean, all we're gonna have are allegations. I don't know if they have any discovery that they can also provide without me being on the case yet.
As of right now, best I can give her is
All right, so this is what I can do. Your client, as I said, can appear by Zoom. I can actually recall this back for May 29th. And if you all are not able to provide information to the court on May 29th, then we'll do it on a different day if defense, that's not enough time for you.
I can do it on May 29th, Judge.
All right, so we'll come back on May 29th. And state, if you wish for the court to continue to have him on GPS, I'll need witnesses.
Yes, Your Honor. We'll have the victim present.
All right.
Thank you, Judge.
All right, once you sign the reset form, you're excused.
Thank you, Judge.
You're welcome. All right, who's here on Adam Keith?
I'm covering that group. She just left.
All right, Norma, they dropped off the Zoom.
Let me call them.
All right, thank you.
Do you have Gabriella Medellin up there too?
No.
Medellin, Gabriella Medellin.
Okay, so all of them have been brought over to the courthouse? Okay. Thank you so much.
I hate the jail.
All right, thank you so much. Bye.
All right, so.
I guess we wait.
Yeah. What's here on Aaron Guillory?
I am, Your Honor, Eric DeWalt. Mr. President in the courtroom.
All right, come forward.
Mr. Guillory, come on up.
Okay, Mr. Hayek, you're gonna have to move because inmates are taking routes that they're not supposed to take according to the deputies. All right, so where are we on discovery? Have you received it all?
I have, Your Honor. It was quite a lot, and I dropped off a disc. I have received it. I've started to review videos. The state hasn't tendered an offer yet. There's a co-defendant in another court right now.
Okay. All right, Norma. Set this for jury trial in July, please. This will be your jury trial date and plea deadline date. How long do you expect this trial to last?
3 days,
All right, they say 3 days.
criminal PTD.
You said July, right?
Yes.
And is this a trial date or can we have one date for an offer date?
Oh, it's a trial date. You're all gonna have to confer off docket.
Okay.
So this date is your jury trial date and your plea deadline date. All right, July 22nd.
Thank you, Your Honor.
All right, they'll bring you over dressed for trial. All right?
Thank
Do
you,
you have
Your
any
Honor.
questions? All right, thank you. Thank you.
Yes.
Huh? All right, Gabriel Medellin.
Judge, that's my case. She has a respiratory infection, Judge. She was at University Hospital. I want to see if we call it for next Friday. So she can go back to the hospital, and then I anticipate next Friday it'll be a plea.
I can put it for Thursday.
That should work.
All right, Ms. Ferguson. Recall this for the May 29th. And that's for disposition.
Just go ahead and see if I can find you.
All right, who is here on Fernando Alvarado?
Judge.
Sometimes I don't have the cases and other people are standing there looking.
I figured I would check.
Oh my
Thank you,
God,
Judge.
okay. All right, let me just put this in the system. And what page is Medellin on, please? Oh, I found it. All right, the court is calling 2025 CR 0033132 State versus Fernando Alvarado. Can I have parties announced?
Andrew Harrison with the state.
Jasmine Olguin for Mr. Alvarado.
And are you Mr. Alvarado?
Yes, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Alvarado, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, Judge.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Alvarado, did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Did you understand you're charged with possession of a controlled substance penalty group 1, less than 1 gram? That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state will call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea in this case?
Yes, Your Honor.
Did you understand if the court were to grant your application for deferred, oh, that's yours.
Oh, thank you, Judge.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea? Anyone promise you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is recommending deferred adjudication. They're taking in consideration JN number 2170834 and 2170835. Did you understand that to be the plea?
Yes, Your Honor.
Defense, is that the plea?
Yes, Judge.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 4 years. Did you understand that was a recommendation from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the offenses charge, how do you plead? Guilty, not guilty, or no contest? State any evidence.
State offers to attachments, Judge.
No objection.
Did you review, state you may be excused. Did you review the waiver and consent to stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you apply for deferred adjudication. Are we proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
No, Judge.
All right. So how often have you used in the past?
In the past, it was only for a few months.
All right. And then are you still with the people who are listed as complainants in this case?
No,
State, okay. And are you employed?
I have a small business.
All right, what do you do?
I have a mobile bartending business.
I'm sorry?
Mobile bartending.
All right. And do you have any children?
I have a daughter. 17.
Age?
17.
All right. This is what the court will do. Probation, are you ready? 4 years deferred adjudication, taking consideration JN 2170834, 2170835, regular reporting by Zoom or in person, regular random UAs, TAP evaluation out of custody, follow recommendations. If you're drug tested today, what are the results going to be?
Negative.
All right, you're going to get drug tested today. You understand? There's going to be 60 sober meetings in 60 days, proof of employment within 30 days. There's to be no employment as a home health care provider or with minors. There's to be no contact with the following persons. Jennifer Lynn Stanley, Stanley, Christopher Martinez. And there's to be a mental health evaluation out of custody, 100 hours of community service restitution, field visits 1 time per month for 6 months. Probation, is there anything else? Is there anything else you need from the court in order to be successful?
Just be able to work.
Oh, you'll be able to work.
I'm on the.
All right, but here's the thing, while you're on probation, you're not allowed to drink alcohol. You understand? All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record in this court. In order to be successful on probation, communication is key. If there's an issue, let your probation officer know about it. If you feel that you're about to drink or you're about to backslide, call probation, let them know. They're going to give you help. If you feel that they're not addressing your issues, you can always come back to court. All right, good luck to you. Just remain in the court until you receive the documents. And counsel, if you'll make sure that they've done the dismissals for the JN numbers.
Yes, Your Honor. Thank you. Have a nice day.
Thank you, you too. Okay, thank you. All right, just give me a moment. All right, just 1 second. Just 1 second. Let me put this in. Yes.
Just need one copy. You just need one copy.
All right. Hector Aguilar.
Who's present?
All right, if he'll come up.
Aguilar?
My understanding the interpreter is here.
That's correct, Judge.
Morning, Your
Good morning. How are you doing?
Very good. Thank you for asking, Judge. How are you?
Oh, I cannot complain. It's a Monday and a Tuesday and a Wednesday, all rolled into Thursday. But hey, it's Friday Eve. You can't beat that. Don't know what that's about,
You
but
make that-
somebody, they may need some help. All right, so where are we on discovery?
Judge, I've gotten some information to the state. They want to go ahead and run that down, so we do need another discovery setting.
All right, this will be the last discovery setting. Ms. Ferguson, I need a 30-day reset for discovery. 30-day reset for discovery on Aguilar.
I can do June 19th. No, I'm sorry. That would be June 23rd.
All right, June 23rd.
Thank you.
And is he a citizen? Does he need an immigration attorney?
Judge, we've got a consultation going on. We don't believe that's necessary at this time.
Well, if he's not a citizen, if this case is not going to be worked out, then y'all need to take care of that. So is your firm going to handle that?
Judge, this case is not, with this, we don't intend to plead to anything, so.
Okay, but I mean, he'll still.
Yeah.
Okay.
Oh, yeah, no.
All right, Ms. Ferguson. Set this on June. Well, we don't need a June 23rd.
We do need, Judge, we've given them some information. There's a bigger context in this case. And so they really do need the time to go ahead and run that down, so it may resolve it.
All right, Ms. Ferguson, June 23rd for discovery. And if things are not worked out, the next court date will be a jury trial date. All right, thank you. All right. Is there anything else?
No, Judge.
All right, thank you.
Maybe it's good, Your Honor?
Yes.
Thank you.
All right, Deputy Laura. Yeah, we can bring the jury in. All right, we have a verdict, so the inmates are going to be taken to the back and the court is going to take the verdict.
Yeah, well, wanted to see what before.
Yes.
I have the complete paperwork ready, but I can't come back this afternoon. Could I
Oh, you can do
recall
it
it in the
by
morning?
Are you able to be by Zoom?
No, I'm gonna be at a doctor.
Okay.
So could I come back in the morning?
Yes.
Thank
Who's your client?
Wilfredo Matan. Matan.
Okay.
Thank you.
All right, Norma, and Matei. The defense counsel, no, do you have the paperwork? When do you need to leave?
Well, I mean, I can say, but I thought you'd quit at 12 and I can't, I could wait.
This, Deputy Laura, if you can put him in a cell in the back.
Yes, Judge, I'll on R for right now.
All right.
Okay, I'll wait for you. Thank you.
All right. Are the parties here on Johnson? All right. It's the court's understanding that there is a verdict that has been reached. All right, for those who are in some way related to this case, whatever the verdict is, there's not to be any outbursts. If there's an outburst, a deputy is going to tap on your shoulder, have you removed from the courtroom. You will only be allowed back in the courtroom if someone needs you for testimony. And then Norma, once I take the verdict in this case, I'll only complete the files that I have up here.
Okay.
And so if you can hand me Matei.
Yes, sir. Can you just swear him in, Judge, and just do it?
But Sean, I'm gonna try that green drink. I hope you're not staring me. I hope you're not staring me wrong.
You can taste everything.
All right, because the last one. All right, we are back on the record in 2024 CR 2675. Are both parties ready?
Yes, sir.
All right, let's bring the jurors in.
All right, the jury.
All right, everyone, please be seated. Ladies and gentlemen, it's the court's understanding that you've reached a verdict in this case. Is that correct? And is that verdict unanimous? All right, if you'll hand the verdict form to Deputy Laura, please. All right, defendant will please rise. Count one, aggravated assault with a deadly weapon. It states, we, the jury, find the defendant, Darren Johnson, not guilty of the offense of aggravated assault with a deadly weapon as charged in count one of the indictment. Count one, the lesser included offense of misdemeanor deadly conduct. It states, we, the jury, find the defendant, Darren Johnson, not guilty of the lesser included offense of misdemeanor deadly conduct under count one. Count two, injury to an elderly individual. It states, we, the jury, find the defendant, Darren Johnson, not guilty of count two. You may be seated. Does anyone wish to have the jury polled? All right, ladies and gentlemen, if you will go back to the jury room and I'll come and speak to you briefly. All right, everyone, please rise for the jurors. Defense. All right, everyone, please be seated. And counsel there, swear your person in, and I'll be right back. so that we can have our little lunch.
I'm doing Keith's plea for Bridget.
All right.
Whenever they bring him out.
All right, who's here on Mia Herrera? Is she here?
They're bringing her back out.
Lynn Morin.
Guys, we're ready on that. Samantha's coming, she's walking down from her office.
Okay,
I'll let you know when she gets here.
all right.
Have a seat. You have a coffee from there.
Axel Ramirez.
President Judge, would like, it's gonna be a plea if we can do it tomorrow morning.
Yes. All right, Norma, Axel Ramirez is going to be a plea recalled tomorrow for disposition. Thank you. Once he signs the reset form, he's excused.
They're bringing the inmates out?
They're bringing some,
Okay, I've got that one for,
you can zoom in if they don't.
that's when they had them on Zoom and then he took them off and brought them over
Yeah.
here. That's sufficient.
Yes. Who is that?
Miss Brown's back in this morning.
All right. And who is his client?
Mario Topa, Judge.
I'm Mario.
Mario.
Yeah, they can come back tomorrow. All right, just give me 1 second. All right, Lynn Morin.
What are you doing?
Hello. So it says Daniel Vella hired.
Dan did the bond. I lead counsel on it, Judge.
All right, Ms. Ferguson, can you make sure that the docket reflects that he's the counsel
Which one, Judge?
on Lynn Morin?
Yes, ma'am.
All right, so where are we on discovery?
Judge, I viewed the state's discovery, went ahead and did that end of April.
Mhm.
I've got some information on our part that I'm supplying to the state. That I'd like them to review before we,
All right, have you turned that information over?
I've not, it's an evaluation. I just got my hands on that, Judge. I'll turn it over to the state.
So state, you'll need to tender an offer to defense counsel off docket. And I am bringing this back on June 26th. Are you here?
Yes,
June, yes.
Out of the country that day.
All right, are you here the week of June 16th?
Yes.
All right, so June 20th will be your plea deadline date.
thank you, Judge.
All right. Norma plea deadline date on Lynn Morin, June 20th.
Thank you.
You're welcome.
Mia Herrera has been brought out, Judge.
All right, just give me a moment.
She's out here.
I know, I told.
Okay.
All right, Mia Ray Herrera. All right, who's on the bond on this case?
Do we not recall who the bond company was, Judge? Do you recall?
All right, y'all are asking to reinstate the bond?
Actually, we're actually asking to set the bond, Judge. But state has agreed to reinstate it. However, at this point, we're just wanting her to get a bond so she can bond out.
You can't, I can't reinstate the bond unless the bondsman is in agreement to reinstating her bond.
That's fine, Judge. I think they meant to reinstate the same amount that she was previously,
And what was the previous bond amount?
5,000, Judge.
All right, so it shows that she was late for court.
That's correct.
Court is calling 2025 CR 003690 State versus Mia Herrera. Can I have the parties announced for the record?
Andrew Harrison, state.
Leo Gonzalez from Mia Herrera.
And are you Ms. Herrera?
Yes, ma'am.
Can you raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
You can lower your hand, state your name for the record.
Mia Herrera.
All right, why were you late for court?
I had just found out that morning that I had court.
All right. And what are you asking the bond to be reinstated at, defense?
5,000, Judge, which is the original amount she made.
State, are you in agreement to the $5,000 bond?
Yes, Judge.
All right, the court will reinstate your bond at $5,000. Counsel, have you received all discovery in this case?
I know we haven't, Your Honor. We were just hired a couple days ago. So we're working on getting that taken care of.
All right, Ms. Ferguson, recall this case for June 9th. State on June 9th, you'll need to tender an offer. And then there will be a plea deadline date set immediately thereafter.
Thank you, Your Honor.
All right, is there anything else?
No, Your Honor, that is all.
All right, Ms. Ferguson, make sure she has a reset form.
Yes, ma'am.
David Johnson.
Thank you.
Have a seat, madam.
And no more files. Court is calling 2023 CR 6703 State versus David Johnson. Can I have parties announced for the record?
Andrew Harrison, state.
Tony Adonis might have Mr. Johnson.
And are you Mr. Johnson?
Yes, ma'am.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same David Wayne Johnson who was placed on deferred adjudication in 2023 CR 6703 for the offense of possession of a controlled substance, penalty group 1, 1 to 4 grams on November 21st, 2024 for a term of 2 years? Is that you?
Yes, Your Honor.
All right, state.
On or about the 21st day of March 2025 in Madera County, Texas, the defendant, David Wayne Johnson, committed the offense of criminal trespass in violation of condition number 1.
How do you plead to that? True or not true?
So really.
State waives the remaining violation allegations.
Any objections?
No, Your Honor.
Did you understand by pleading true to violation of condition number 1, the court could find it true, grant the motion, find you guilty, and sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 1?
Yes, Your Honor.
Court will find violation of condition number 1 true. Is there a proposed agreement?
Yes, Judge, a jail sanction with credit for time served, deny the motion, the jail sanction with credit for time served. Alternate amend to include the cognitive behavioral therapy course, and the state will take into consideration and dismiss. File number 2025 F10873.
That is agreement.
All right, you're gonna raise your right hand for me. Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, why are you not doing well on, you can lower your hand. All right, state your name for the record.
David Wayne Johnson.
All right, why are you not doing well on probation?
I got kicked out of my apartment, Your Honor, and I was trying to get in the middle of getting another apartment when all of this happened. And they arrested me, took me to jail. That's why I was in custody and I was supposed to report. But I was in custody and I couldn't report that day.
What had happened, Judge, is that the apartment complex where he and his wife were living had filed an eviction, and they were evicted the same day that he was arrested. What happened is that they were put outside the apartment. It was very hot. They were there till the evening. His wife was getting sick and she was overheating, and they felt the only thing they could do was go back into the apartment to try to cool her down. As soon as they did that, they arrested both of them and charged them with criminal trespass. And he's been in jail since that day. His wife is also pending charges for the same criminal trespass.
All right, the court will deny the motion, alternate amend conditions to include proof of employment. Are you on SSI or are you employed?
I'm employed.
All right, proof of employment within 30 days, no employment as a home health care provider with minors. Taking consideration 2025 PF 10873. Probation, is any further recommendations from probation?
None other than that cognitive behavior approach, Judge, but I don't
Does he?
think that that's really necessary.
All right. All right, thank you.
Thank you.
Norma,
Yes.
if he's the attorney who has something with his son, he can go do that and he can come back tomorrow. But I'm only taking up the cases that I currently have. Who's here on Mate or Mate? And Nora, what page was Herrera on? Or is that something that was off docket?
I haven't taken it. 9.
Thank you. All right, court is calling 2025 CR 002-719 State versus Wilfredo Mate. Can I have parties announced?
Andrew Harris, Salem State.
Brian Kimbrough from Mr. McKay.
Are you Mr. Mate?
Yes, ma'am.
Counsel, have you received all discovery? Did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Sir, did you review the application for deferred adjudication with your attorney? Did you understand it and sign it?
Yes.
Did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge State waives the offender enhancement allegation.
No objection.
Did you review the admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with evading arrest detention with a vehicle? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow the plea. If for any reason the court does not follow the plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason the court were to revoke your probation, court could sentence you up to 10 years in the prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Sir, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 10 years in the prison. There's a $2,000 fine. State is silent on your application. They're taking in consideration 2025 CR 003-472, 2025 PF 11391. Did you understand that to be the plea? Defense, is that the plea?
That is your.
State, is that the plea?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written to retrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there many such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Contained in exhibit 1 and attachments, Judge.
No objection.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to a jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments. The court has reviewed the same. The court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt. Counsel, we can set this for a PSI. It's going to be about 8 weeks, or if you want, I can call it back sooner and you can present whatever evidence you would want to have presented.
I'd like to get a PSI.
All right, I need a date for PSI.
June 10th.
All right, June 10th.
Oh, okay. Thank you.
Thank you. Yes.
I'll see you.
Have a seat, sir. Thank you. June 10th.
Judge, may I approve?
That's all we like. July.
Misty Del Porter from yesterday entered her plea on the criminal trespass.
All right, it's July 10th, counsel.
Oh, July 10th? Okay.
Thank you.
You're welcome. John Arredondo. Court is calling 2022 CR 7676 State versus John Dylan Arredondo. Can I have parties announced for the record for the state? Defense.
Roberto Ambrosino?
Are you Mr. Arredondo?
Yes, Your Honor.
Did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? Did you understand it? Are you the same John Dylan Arredondo who's placed on deferred adjudication in 2022 CR 7676 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram, on September 22nd, 2022 for a period of 4 years? Is that you?
Yes, Your Honor.
State?
In Bexar County, Texas, the defendant, John Dylan Arredondo, had then and there failed to report to the supervision officer as directed for the months of January 2025, February 2025, in violation of condition number 4.
How do you plead to that? True or not true?
True. State waives the remaining violation allegation.
Objection.
All right, did you understand by pleading true to violation of condition number 4? The court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
Yes. Adjudicate guilt, revoke supervision, excess punishment at confinement in the state jail facility for 180 days.
Is that the agreement?
It is, Your Honor. I believe he has that amount of time served.
All right, so what has he done since he's been on probation? Has he done anything?
He has spent much of his time on probation on parole and some of it in custody. So I think that did present a problem for him getting a lot of it done.
Drug addiction.
All right, probation, has he done anything?
Judge, it appears that he completed state ISF 122 days. And and completed his top evaluation. That's about it, Judge.
All right, the court is going to grant the motion, find you guilty or revoke, sentence you to 365 days in the state jail facility, give you credit for any time served and credit for any inpatient treatment. All right, did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and did you sign it?
Yes, sir.
All right, you have a limited right to appeal. That right to appeal is as it relates in the, to the allegations in the motion, not the fact that you are on deferred adjudication. Do you understand? All right, because you've been found guilty, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, good luck to you. You're gonna have to do better. You understand?
Yes, Your Honor.
Okay.
Thank you.
Think if you- Who's here on Hunter Edwards?
I am, Your Honor.
Sorry, just give me 1 second. All right, court is calling 2025 CR 0039914, State versus Hunter Edwards. Can I have parties announced for the record?
Andrew Harris, Tatum.
Phyllis Bill for the defense.
And are you Mr. Edwards?
Yes, ma'am.
Counsel, have you received all discovery in this case and did you review it with your client?
Yes.
Court will find that the state is in compliance with discovery. Mr. Edwards, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Edwards, did you review the admonishments with your attorney? Did you understand it?
Yes, ma'am.
Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that if you have a plea, did you understand that you're charged with fraudulent possession or use of credit or debit cards less than 5? That's a state jail felony.
Yes,
Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that if the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he is currently competent and was legally sane at the time of the offense?
Yes.
Mr. Edwards, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promise you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 6 months in the state jail facility. There's $1,000 fine, no applications. The state will take in consideration 2025 CR 003515, 2024 AL 007526. Did you understand that to be the plea?
Yes, ma'am.
Defense?
Yes.
State?
Yes.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, there be any such motions? Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence.
And then exhibit does not have.
No objections. Did you state you may be excused? Did you review the waiver and consent to stipulation of testimony and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
Court will sentence you to 6 months in the state jail facility, give you credit for any time served. There's a $1,000 fine. Taking consideration 2025 CR 003-515, 2024 AL 007526. There's to be no contact with Tory, Tory, Cornelius House. And there's to be restitution, if any, to the complainants. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you. Don't build your happiness off other people's misery. You understand?
Yes, ma'am.
All right. Norma,
Okay.
we're taking our break.
Have a seat, Sue.
It's 12:30.
They have Mr. Keith out.
Oh.
He's waiting for Bridget.
He's out here.
Yes, he's here.
Bring Mr. Keith up.
That's all right.
And I explained to him what's going on. It's a discovery issue.
What is the discovery issue?
Bridget said there, I guess there's a flash drive that she's supposed to provide, and they're gonna download some additional discovery for it.
All right, this is coming back for an update discovery on June 16th. And plea deadline date,
And that's
June 16th. That is Adam Keith.
Right, and I'll get a copy to Bridget.
All right, thank you.
I'm gonna have you sign it. Norma, do you have the inmate sign?